Συνεχίζει το ίδιο θέμα στην ουσία η επόμενη παρέμβαση, νομίζω, της κυρίας Παραλίκα για τη σχέση μεταξύ διαιτητών, σε πιο ήπιο βέβαια κλίμα, φαντάζομαι. Σε πιο ήπιο κλίμα. Όχι, από ναι, αυτά, εννοείται.
Καλημέρα και από μένα. Ευχαριστίες πολλές στον καθηγητή Καλαβρό για την τιμητική πρόσκληση να είμαι σήμερα ανάμεσά σας. Και η παρέμβασή μου θα γίνει στην αγγλική γλώσσα. So, I will be exploring the issue of whether social relationships between arbitrators can be a source of bias or rather an effective tool in the arbitral process. Now, in international arbitration, tribunals more often than not are composed by 3 arbitrators. And the pool of international arbitrators is limited to what is generally considered a relatively small number of arbitrators. Now, why is that? It has been argued that one of the reasons that explains this is that arbitrators benefit from what is called heuristic biases, risk aversion by the parties, and a desire to reach a predictable outcome. Whatever the reason may be, players in the international arbitration network, be it arbitrators or counsel, are likely to work together more than one case, and very likely also in different roles, that of arbitrator or counsel. So I thought that this would be an interesting picture to show you to illustrate the point. Now, the dots on this picture represent names of arbitrators involved in investor-state disputes, and the lines that link the various names show which arbitrator has sat with whom in the same arbitral tribunal. Of course, so this picture shows how dense this network of relationships is. Now, in commercial arbitration, one can argue, obviously, that this network may not be as dense, but unfortunately, we don't have a similar chart. And again, this chart may be imperfect, but it does remain a good source of information when looking into relationships between arbitrators. In addition, as you know, arbitrators act as counsel act as arbitrators, and they all meet at different capacities in different hearing rooms, in conferences, and may have even worked together in law firms. Going a step further, the same people are bound to form relationships that may go beyond the strict professional boundaries, and that it would only be normal for human beings to relate with each other outside of their profession. So it seems that ties between arbitrators is an issue that is a little bit overlooked by arbitration rules. Arbitration rules focus more on the independence and impartiality on arbitrators, but they're oriented towards parties and not the other arbitrators on the same panel. For example, the provision of the ICC rules provides that every arbitrator must be and remain impartial and independent of the parties involved in the arbitration. That said, the ICC's note to the parties and arbitral tribunals recommends that arbitrators should disclose relationships with other arbitrators. An interesting article is that of Article 10.1 of the 2010 rules of the Netherlands Arbitration Institute, which has been removed since then, but was the only one that I found that provided that arbitrators shall be impartial and independent also towards their co-arbitrator, not just towards the parties. So generally, relationships between arbitrators have rarely been recognized as a factor in the conduct of the arbitration that may have an impact on the impartiality of the arbitrators. Now, let's have a quick look at the IBA guidelines. Now, IBA guidelines refer to relationships between arbitrators under the green list. So these are circumstances that do not need to be disclosed, and also under the orange list, but very specifically, arbitrators are encouraged to disclose whether they have been lawyers in the same firm as other arbitrators, members of the same chambers, or acted together as co-counsel. So this is a very restrictive list. And it is interesting also that the IBA guidelines suggests that close relationships or enmity should be disclosed when they exist between an arbitrator and counsel of a party, but not between arbitrators. So, as Christoph Müller explained during his speech, arbitrators are human beings and can be subject to various biases and be subject also to various psychological influences. So the question is, can these close relationships lead to biases, and how? Arbitrators have somehow to live together during the life of the arbitration in which they're working. They meet, they discuss, they exchange views, they may have a drink after the hearing, they communicate by email or phone, they deliberate, they can spend several days or weeks during and after the hearing on the same case. So there's a lot more in this relationship than what the parties see when they see the arbitrators sitting in a hearing room. And these relationships, in most cases, are far from being ephemeral. And of course, I suggest that this may lead to bias. And of course, because there's no out there any regulation as to how arbitrators are to deliberate, how they are to communicate in order to draft and issue their final award, the arbitrators conduct their deliberations as they see fit. Now, these ties between arbitrators can be proved to be an efficient tool. Indeed, many very well-known arbitrators do insist on the necessary social aspects of the arbitral decision-making. Pierre Tercier, for example, suggests that arbitrators must get along well for a tribunal to function well, and speaks of a special club des arbitres, which shares many common interests beyond the issues of the case that on which they are appointed and act together. Yves Fortier also suggests that members of a tribunal must establish a bond, and that the better they know each other, the better and more constructive their deliberations will be. He goes as far to note that the chemistry which prevails among the members of a tribunal becomes as important as their experience and expertise. And Lucy Reed advocates the so-called Reed's retreat that suggests that arbitrators should meet before the hearing outside of their offices and brainstorm the case. So this can be indeed a very effective tool. It can also be a source of bias. What form, specifically, can this bias take? Can a president of a tribunal, for example, unintentionally favor one of his co-arbitrators over the other? Or may a co-arbitrator side with the president's view and isolate the other co-arbitrator? Can two arbitrators form a so-called clique and exclude effectively the third arbitrator from the deliberations? In reality, nothing stops a president from meeting with one of the arbitrators with whom he or she may have a close relationships in informal exchanges, including in writing the award. And another example is in the UK, there is a practice that barristers belonging to the same chambers may act as arbitrators in the same proceedings. And it appears that in such cases, the junior barrister may end up drafting the award for the senior barrister. And of course, such relationships may lead to the exclusion of the third arbitrator from the process. And this may not, of course, be intentional, which is why we're talking about biases, but it might arise from what Rusty Park describes as the moral hazard implicit in any hidden-in group complicity. So can the arbitrators be trusted to be independent and impartial despite previous and ongoing contacts between them? It's difficult to answer this question because there are not many challenges that we know of that deal with that very question. So in concluding, I believe that personal affinities between members of the same tribunal may prove very useful and essential for conducting effective deliberations. But arbitrators should be aware, should be conscious of their own unintentional biases caused by their own social relationships, and should definitely not underestimate them. And of course, I believe that it also comes down to the president of the tribunal to play an important role and establish a very good working relationship between the members of the tribunal. So I would be very interested to discuss this further, hear of your own experiences and examples, and thank you very much.